sign the complaint
Okay.
name. And when the judge reviewed it for probable cause or not for probable cause, it's done electronically through the system.
Okay.
So I wrote his name because he's the one that found PC or didn't find PC.
So you wrote his name?
Yes, that's my handwriting.
Okay, so he's never signed it.
It's electronic signature. It's done computerized.
There's no signature. That's what, look, and I'm not trying to. Go ahead.
If you're gonna keep interrupting me.
I'm not interrupting. Keep talking. Please.
So because he does it in the system, he's not in our building, he's not one of our judges.
Yeah, I know.
They find probable cause in the system and they click a box. It's done in the system electronically. Because of her signature being not being electronic, because complainants cannot sign electronically, I wrote his name as though he found probable cause.
So
he did in the system find probable cause.
Okay, but it's not signed, which by that it's not legit.
It's the signature. The S.
No, you signed it, not the judge. I don't even know if the judge looked at it.
What? I didn't hear what you said, sir. I'm sorry.
I don't want to overtalk. That's all. You signed it, not the judge.
I signed it on behalf of the judge.
Doesn't work signed by the judge.
It's signed electronically in the system by the judge.
Can I have a copy of that, please?
See if I can get you one.
Because it's page 307, I believe, on both of them.
Yes.
And then also my original complaint I need a copy of.
I'm sorry, you need a copy of what? I can't hear you.
My original complaint.
And $1.99. This is a copy of your original complaint. And unfortunately, the other two were transferred out to Washington Township, so I don't have the originals.
This is one I wrote.
I'm sorry?
That's not what I wrote. I have this all on video. She's the one that called in on her property, in her window, spitting on her.
Okay.
Yes, ma'am. Tricia.
You need to get a copy of what you wrote?
Well, if this was dismissed based upon this is not what I wrote.
If you wrote a statement for her...
Yeah, 2 pages.
I don't have that. She never provided that for me.
Dismissed, yes.
Let me just finish and then I'll let you talk. I promise.
Thank you, sir.
I always do. You don't have discretion here. I do. This is what I'm doing. I was kind of hoping you'd be good with it. It doesn't make a difference what you think. It doesn't.
Okay.
This is what I'm going to do. I was kind of hoping that you'd be happy with this. I can tell now that really nothing's going to make you happy, and that's okay.
The judge's signature.
You do what you got to do. Really. You do what you think you have to do. But this is what I'm doing.
I understand.
Mr. Prosecutor, it's my understanding that you are moving to dismiss these charges without prejudice for a period of 1 year in the anticipation that there won't be any additional similar allegations, correct? That is correct, Your Honor. Mark, do you have any questions about the state's position?
No.
Anyone?
No.
Oppenheimer, then the charges against you are dismissed, all right?
It's, you know.
I'm glad you appreciate it. I'm just telling you what to do. And oddly enough, I don't get upset about it. You do.
No, sir. You know what I'm upset about? I did not agree to without prejudice with you. But that's fine. Last time we spoke, I have the tapes of it. I did not agree to it, but that's fine. Let's just go to trial. Because nobody can still get me.
You said that I dismissed your case.
No, you said.
That I dismissed your case.
Again, sir, I did not want it dismissed without prejudice. It's all on recording. They have recordings of the event. It's simple. Let's go to trial.
Very good. So I'm going to let the judge know you're going to get a lawyer.
Yeah, I also need the paperwork with the digital signature. And unfortunately, Alicia Moser wasn't able to do it, but she did say that I'll get it now. She just said it that I'll get it now within 7 to 10 days, which that will.
You'll get what?
I'm still looking for the digital signature with the judge. You know, nobody's been able to actually provide me with that piece of paper. And Alicia now says she located it, I guess.
That's not my concern at this point.
It is my concern because if the judge never did it, then it's not even valid to begin from, from the beginning, which is sad.
Right. And you know what? It's like you definitely need a lawyer, and you're suing everybody.
Oh, sir, guess what? So you have, you have the CDR, because the Mantua police were just here.
Thank you very much.
Okay.
It was September 16th of last year that there was the conditional dismissal. The matter was reinstated. The prosecutors indicated that you are going to hire a lawyer.
We're going to trial.
That night.
And any paperwork y'all can provide me with, I'd appreciate it.
I mean, all we would have at this point are these complaints that were reinstated. Again, this complaint number S2020-197 and 198 issued through Mantua.
So you have it right there. You see the signature?
I have those complaints in my hand. Those two complaints were sent
Right.
over to me from Mantua since there was a conflict issue.
Right. Which is your digital signature on it, sir? With the hash, time and date?
Yeah, no, I have. Yeah, I it does indicate that I'm the signing judicial officer for those, and it could have been done telephonically, which would, if that was how it accomplished, then it would have been signed by the person that reviewed by telephonic.
She stated that it was done through the CDR system.
Again,
I know.
tell me things
I know, sir.
that I have no way to verify.
I understand. I just rightfully want the right paperwork. That's all.
Okay.
All right, sir. Thank you.
The matter is rescheduled. All right, thank you. Have a good day.
All right, sir.
And what do you want to do?
Go forward.
All right, we'll schedule it for a trial date then.
I thought we were doing that today, sir.
We're not doing a trial today.
Okay.
Again, it was postponed for you to get an attorney at your request.
And I
Not
had
mine,
another
yours.
court. No, it wasn't
No,
really my request.
That's fine. If you can't get one, you
I
can't
told
get
the
one.
judge I
But-
would get
but
one if I
please
could,
understand
sir.
that it was postponed because you wanted the lawyer.
Sir,
Yes.
today was the trial date. I'm ready.
No, it's not.
Okay.
Talk to the judge. Okay?
No, I mean, it's all good.
Have a great day.
You too.
Hit the leave room button and talk to the judge.
Sure. Have a good one, sir.
I can barely.
Have a good one, sir.
You too.
Thank you.
All right.
Good morning, Your Honor.
Good morning. And can you state your name, please?
John William Eppiheimer.
Thank you very much. Okay, sir, I am seeing you for these complaints. I spoke with you before. There are 3 total complaints, it appears, at this time. I have, just to make sure we're all on the same page. I have S2020-197 and 198. Those were before the court previously, initially dismissed without prejudice, and they were reinstated, so you're aware of those matters. We've gone over those before. And just so you know, there's a separate complaint now for harassment on complaint number S2021 number 9. And this alleges harassment from January 9th, 2021. Initially it was harassment and cyber harassment, but now it's just the 1 count of harassment. The complaint number 10 alleged cyber harassment, which is a 4th degree charge, but the certification was identical to the certification on complaint S2021 number 9. And the county prosecutor reviewed the one that was at the county level and downgraded it to harassment, but there's already a harassment complaint for the exact same
Right.
charge. So they're duplicate complaints at this point.
I understand.
On cause on behalf of the state. Again, Your Honor, I think we have 4 complaints in front of us, but essentially we have a threshold issue between the most recent ones, S2021 at 10 and 9, and S20 197 and 198. Again, the threshold matter between the two is would the allegations contained in the 2021 complaints be sufficient to violate the terms of the no contact order issued as a result of resolution on 197 and 198 from the previous year? If they do not, then the 2020 issues remain on ice, so to speak.
Well, they were previously dismissed without prejudice, is what you're referencing, approximately a year, according to
Yes. They were dismissed without prejudice, subject to a no contact order, and so that would be the issue on 9 and 10. Are the actions alleged in 9 and 10 of 2021 sufficient to violate on its face the no contact order on the previous year's dismissal without prejudice?
Your Honor, if it would please the court, what no contact order?
I thought that was the understanding as to what you would agree to when the matters were dismissed without prejudice, was that there would be no continuing.
I agreed to nothing, sir. I had wanted to go to trial. I have it on tape right here telling them. I have it on video. I can play it for the court if it would please the court.
Yeah, but when the matters were dismissed without prejudice, I believe the representation was that you were going to go your way and not have any contact with the complaining witnesses.
Sir, this is an election year, I believe, and I've not had contact with this witness.
Okay. Well, I think that's what the prosecutor might be stating. So why don't you just bear with us for a minute, and if
Okay.
you have any questions after that, then we'll go from there. Okay.
Okay, sir.
Mr. Oppenheimer, if you want to interrupt me again, please just let me know. Raise your hand or something.
No problem, sir.
Right? Yeah.
No problem, Counselor.
Thank you, sir. Anyway, so the question is, does the action complained upon in the 2021 complaints rise to the level of a violation of the no contact order set down the previous year? In a review of the two complaints, I believe that the actions complained in 9 and 10 are essentially the same actions, which boil down to Facebook posts, not directed at, not directed to Ms. Pennywell, but certainly in part about Ms. Pennywell. In a review of the case law, which I have done and have experienced over the last month or so, and I did just re-review this from my files. I don't believe that the posts on Facebook, because they were not directed to Ms. Pennywell, are a violation of a no contact order. I think it would be an infringement upon Mr. Oppenheimer's free speech rights to make comments, particularly about a public official. Whether they're accurate or not is a whole other issue. I think he has the right to do that. As distasteful as it may be, and it is, as interpreted by the intended recipient of this as offensive, which it is, I still think his rights, his free speech rights, have to be abided by, and I don't believe that the complained actions are a violation of the no contact. I think Mr. Oppenheimer certainly skirts and runs a fine line on it, but with the recent case law from the Supreme Court, I don't believe that his rights should be infringed in this manner. And therefore, I don't think the actions complained about are a violation of the no contact order with Ms. Pennywell. That being said, once I don't believe that 9 and 10 of complaints 9 and 10 can hold up, the state would not be prosecuting these, and therefore the complaints in 2020, 197 and 198 would remain dismissed without prejudice, with a further recommendation of a direct no contact order, and as an aside, Mr. Oppenheimer, just stop. You're skirting so many issues here. I'm siding with you, and I know you're going to rebut it, but just stop. But that being said, the state cannot, in good conscience, prosecute 9 and 10 for free speech rights that Mr. Oppenheimer has and did exercise. Again, I think he's definitely skirting these issues, but I have to err on the side of his constitutional rights. As such, the state would be moving to dismiss complaints S 2021-10 and 9 based on the reasons stated on the record.
With prejudice.
Was there an allegation that Ms. Ms. Parks was contacted following the prior resolution of those older charges?
Not under these complaints.
Yeah, I just don't, if Ms. Pennywell was the one who followed the follow-up complaints and alleged the violation of the order, I just don't understand.
By 197 will be reinstituted.
Yeah, Ms. Parks' complaint was reinstated. I don't know if it was or not, if it's been reinstated or she was just notified since she was a complaining witness on the underlying matters.
They were handled as joint matters, and maybe that's how that happened. Again, the state's sympathetic to Ms. Pennywell's position because there's clear intent here, but I think the state has to abide by Mr. Oppenheimer's free speech rights. And this doesn't come easy, and it only comes as a result of the recent court decisions from the Supreme Court, further protecting free speech rights, and it's a balancing act, and I think I have to err on the side of protecting his constitutional rights, his free speech. Not happy about it, but that's how it's got to go.
Mr. Oppenheimer, do you see any reason why you would need to have any contact with these people moving forward?
Again, Your Honor, it's a, it would please the court if I speak. I believe he's referring to citing Burkett, the case State versus Burkett, which also, it mainly covers C, and it has a little bit to do with A. But I'm not contacting Miss Candace Pennywell. I don't know her, so I have nothing ill will towards her. But it is an election year, and there's things that are going on with the people that are looking to be elected, and that is my post. The directive of my post is factual information that goes along with other parties, and she just happened to be one piece of stuff that was put together. So I question job qualifications, Your Honor, for a CFO position. I'm a citizen of Mantua. I think I have that right to question that and question resume. That's what I have done. I've not done anything. I have actually been chilled, we'll use that word, per Burkett, of my ability to have speech.
And so you're aware of your rights and what would constitute a harassment violation, then I assume you've been reading the case law.
Yes, Your Honor.
All right, don't run afoul of it.
No, I'm not. I won't. I promise.
Okay, so I appreciate your promise. Prosecutor has made a determination based on his review of recent case laws. It's juxtaposed with the allegations made before Mr. Oppenheimer that he would not be able to sustain his burden of proof beyond a reasonable doubt. Again, based on that, the clarification, if you will, of what constitutes harassment in a relatively similar situation. So the prosecutor does have that discretion, so we would not be moving forward with these complaints. But Mr. Oppenheimer, I think you realize that the complaining witnesses are very sensitive to your communications, and the court would certainly be here to address any ongoing complaints. Let's just hope that make sure that there aren't any additional complaints filed, or you'll find yourself back here having to make your arguments again and run the risk of a conviction.
Can I speak, Your Honor? I wish at the time when I first brought this, the post up with you, if somebody would have just came and showed me what was wrong, you know, where I was wrong with what I had typed. That happens all the time. Newspapers, I've owned websites that were press. I've had press passes and done articles for years. There's no ill will there. I mean, I wish somebody would have just showed me where I was wrong.
Right. Well, I think maybe you know now where the line is. Don't cross it, please.
Okay, sir.
All right.
Excuse me, Your Honor, can I speak? Counsel, are we gonna bring up what happened in May, or is it not part of this?
It's not part of this because in further review of the complaints, the 2021 complaints were filed by Ms. Pettibone. There were allegations of contact by towards Ms. Pettibone. Above and beyond what we just discussed, the no contact order with you was not violated in such a way that ended up in a complaint filed by you. And that was just a little confusing to me. I did have to re-review that along with the case law. So again, your case will not be reopened for in your matter for the reason that there is no allegation that he violated a no contact order with you. So there would be no legal reason to open it up.
And Mr. Parks, the complaint that you were the complaining witness on was dismissed just about a year ago. And as I indicated, I'm not sure why that was even reinstated, as there was no allegation that Mr. Oppenheimer had done anything to you to warrant that be reopened.
Okay.
I think when the court saw that there was an additional complaint from Ms. Pennywell, they just, since these were at one point sort of consolidated matters, they just put them all back on the court docket. I don't think there was any request from you that your old complaint be brought back, so it really hasn't been brought back, is the answer, I guess. Mr. Oppenheimer seems to understand what caused a lot of this distress for both you and Ms. Pennywell, and has promised to the court that it won't continue. The court is here in the event that there's perceived criminal conduct. Please don't hesitate to fill out the appropriate certification, and that would be reviewed if it's still a conflict for whatever reason with the Mantua court, and it will be transferred out for resolution.
Well done.
All right, thank you very much, everyone. Have a great day.
Your Honor.
And the court's going to move on to some administrative matters.
Your Honor. May I please record? How do I get my bail back?
It would be refunded.
Oh, okay.
From Mantua. Yeah,
From
Mantua
Mantua.
would be in possession of that. Washington Township was not.
Okay, sir. Thank you very much.
Thank you. Okay, the next administrative matter that I have to review involves a Matthew Tangrady. Matthew Tangrady was charged on complaint number W 2021-73 with theft. It was an indictable offense on warrant downgraded to municipal court level theft. The defendant was on pre-trial service monitoring, and he has failed to appear. And each listing here in May, June, now on today's date. So for his continuing failure to appear, issuing a bench warrant will be in the amount of $1,000.